Okie doke. Recording in progress. What we're going to talk about today is the IABS and the buyer's rep, which was a follow-up that one of the newer agents had asked me about. She's not on here right now, but hopefully she'll get nudged and join us. We're going to just go over those two documents and how to talk through them with clients. And then I also just wanted to give you guys a quick update. I know you had asked on the last new agent check-in that Angela did with Sierra. Sierra mentioned so much her listing process that she follows the Thomas Wright way kind of, and we have a listing process class that kind of encompasses his way, and we're going to offer that soon. I'm waiting to figure out what the exact date is, but as soon as we have it, we'll let you guys know. This is a class that if you're new to the company, you absolutely need to come to, just to kind of understand the way that we recommend that you do the listing process. And if you're new to the business, 100% it's the right way to kind of learn and set up your process. So what we'll do now is I will share the IABS. Let's see. I have it pulled up. And then we can just walk through it. So you guys, who, if you've just taken your real estate classes, you might know more about this form than I do because I'm sure they taught you about it. So what do you know? These classes will go better if you share and if we talk, because you guys also learn best from each other. So who can share what they know about this document or how they use it or when to use it? Go for it. Yeah.
I've always just in the very beginning, like when you're first meeting with your client, or even just speaking with them, you can send it to them, or if you meet them in person, just bring it to them, just so you can educate them on exactly the different services.
Right, that's right. The rule of thumb is that you introduce this document at your first substantive conversation about, hopefully you guys are still looking at your first substantive conversation about the business, which, and it just kind of, it's kind of a CYA, but it gives the clients like a basic primer, like she said, just to let you know like who's who and what's what in writing, right? And we have a link to this in our signature blocks, but you should be presenting this to them in writing, in paper format or at some point the very beginning when you're first starting to talk to them. Typically it goes hand in hand with the buyer's rep. It's a nice way to do it, to kind of make it official, to say like we're working together, right? And it just, just to go over the document, it kind of explains what's a broker, what's an agent, what are our duties, who can represent who, how does intermediary work, which I think is a really, really important one for agents to understand, because intermediary is when the same broker represents both parties. And there's two types of intermediary. There's intermediary without appointment, which means the broker is not going to assign two different agents to represent, and one agent is going to represent both. And if you do that, if you do intermediary without appointment, the things that you can do are very limited, just so that you're not favoring one side or the other. You basically become kind of an information and paper pusher. You can't give advice. You can't counsel them on what they should do. You can kind of just give them the facts and tell them like what the industry standard is, but you can't really counsel them. I was talking to a new agent the other day and he was doing intermediary and he's like, well, I still consider the seller my client. And I'm like, well, then you can't. That's totally wrong. And I sent him all the TAR stuff on intermediary, because you have to be really, really careful. As an attorney, we are legally prevented from doing that. You could never, as an attorney, represent both sides. So the fact that realtors can do it is kind of, I think it's a farce. I think it's really, really hard to do. It does happen. You just have to be really careful, especially right now. To do both sides is really tricky, because when it gets extra hairy is when there's multiple offers. So you have the seller and you have a buyer, and now all of a sudden there's another agent that brings a buyer. It's really hard for you to be in that situation. And I would never, ever recommend trying to do intermediary without appointment if there's a chance you're going to have multiple offers. That's me personally. But Angela, I don't know if you have thoughts about that.
No, I was kind of raised, the team that I was on for a long time, our policy was, even if we'd assign it to someone else in the group and give a referral feedback. So just to do that. So it's hard for me to wrap my head around it also, as an attorney and someone who for 9 or 10 years was like in an environment where we just didn't do it, but it is done. So, but if but you've just got to be so careful. No strategy. It's just kind of just the facts. So, and you can't, and as Doreen said, when it's multiple offers, it's almost impossible. You just know too much.
Yeah. It's like, and like what Angela said, if you're in that situation, it's always a good idea that if I had a listing and a buyer, and I knew Melissa was going to bring me a buyer also, I might call Angela and say, hey, Angela, can you represent this buyer on this particular deal? And you do it for like 1.5%. Since I'm giving you like a hot to trot buyer that's ready to write the offer and you don't have to show them, you literally would just be representing them. And then if it doesn't work out, she could always give them back to me and I could just pay her for her time, or we could figure something out, right? Like that's the beauty of being at Briggs Freeman. There's so many good people that you can refer things and help people with. So that's just my little diatribe because it happened to this week and I was like, it makes me very nervous because we also get the phone calls when things aren't going right. Right, Angela?
Right.
So,
Absolutely. And then we have an intermediary form if you are in the situation on either appointed or non-appointed that you need to use in addition to that. So.
yeah. And we'll talk about that when we go through the buyer's rep, but absolutely you have to pay for it really properly. This is probably an area where agents really get themselves into hot water a lot. So it's important to pay attention to. But anyway, this is the IABS form. And let's see if I can there. Can you guys see that? Is that big enough? Basically, if you can fill this out one time and save it, then you're good to go because you're going to put Briggs Freeman's license number in contact information here. And then Robbie is our designated broker. So you put Robbie, his individual license number. Then you're going to put whoever is the supervisor in your office and their license number and contact information, and then yours. And then you're good to go once you.
I believe it's now linked. What's linked to the email signatures is completed. So
yes.
I think yes. So you can
That's
just
right.
do that and print that and save it as in your
Yeah.
files as a template.
So there's not a lot of tricks about this. The only other question that I get asked sometimes by new agents is, do I need to have like a stack of these at open houses? And you don't. At an open house, that's like an exception where you can kind of have a conversation about the property with the prospect without having to present that. You can, it's not going to hurt, but you don't need to like hand this to someone before you can talk about the house you're holding open. So that's the only questions. Do you guys have any questions about this document in general? This one's pretty straightforward. So did I stop sharing somehow? No.
No, you're sharing.
Okay. All right. So now we're just going to go through like we did last time, the buyer's rep form, like we did the listing agreement, just to, because there's a few provisions in there that I think are a little bit surprising and also that get like frequently asked by clients. Let's go through it. We'll do that. So this is our, it's a TAR promulgated form, the residential buyer tenant rep agreement. And we're going to walk through just how to fill it out. If you guys have questions as we're going through there, questions that you've come across or something that doesn't make sense, just speak up. Sorry, I'm trying to get my window to hide so that I'm not always, there we go. Okay, so you put the parties, you put the clients and the broker name, and you can put your name underneath since you're the associate. And then, the client's granting you their exclusive right to be their agent, which means that you kind of represent them. And then you define here, like where exactly you're going to be their agent. So, the market area, sometimes if people are like, I'm not ready to, they know they want to look at a specific house, but they aren't ready to engage you fully, you could put just a property address in here. But your other option is to put, just DFW Metroplex. Hey there. That's another, you want to put some type of area in there, right? Some physical boundary. So I used to just put Dallas Fort Worth Metroplex, and that kind of covers you here, or North Texas, or, whatever. So you do need to define what the market area is. So and then the term, I would always say you would want at least a 6-month term, but it doesn't have to be that long. Again, if people are hesitant to sign something, you could do like a 1-month term or a 2-week term or what have you, right? Angela, what do you usually put in that?
I think 6 months is always the best. And I always kind of do the greater DFW area also, but you will have people sometimes. And I think in this crazy market, there are some people who, especially like with higher end stuff, they don't want to be locked down, and they're going to make because they know people have hip pockets at different companies, and they may ask you, I'd say start broad. And if they ask you to narrow it down, they may just say, just for this property or this week or whatever. But yeah,
this
often
property,
with the
this
greater
week, this
DFW
weekend.
area in 6 months. So
Yeah, exactly. 6 months. If you can get a year, great, go for it. Because that covers you from not having to renew it if you run out of runway after 6 months, right? But I would say at least 6 months. So anyway, the broker's obligations, this is what we're saying we're going to do, right? We have to have a benefit of the bargain for both sides in a contract, which this is. So you're going to use your best efforts to assist client in acquiring property, and then you're going to assist them in the negotiation to acquire that property. And then you're going to comply with everything else in here. And then the client's obligations, they're agreeing that they're going to work exclusively through you. They'll let others know that that you represent them. So that's good. I mean, they're making some agreements to you, right? Which is important. It's good to know kind of what their responsibilities are. And then they're going to comply with the other agreements. We have a question in the chat that says, how do you avoid clients cherry picking brokers from signing short-term buyer agreements? I mean, you kind of don't. You just have to have them know your value and want to work with you. Like Angela said, in this crazy market, I know that there are brokers out there convincing them that everyone's trying to say, like, we have hip pockets, and they don't want to commit to one because they feel like they're missing out. So it's hard to avoid. I don't know if you guys have any other ideas of how you can avoid that.
And like you said, I think it's your value. You just
Yeah.
gotta show prove your value.
Right. Yeah. And I mean, the good news is that you're associated with a really strong brand, that we do a lot of off-market transactions. And so that's really valuable. I put that out in an email the other day. I said, I have friends that live in Denver. They've always worked with like a different realtor because my friend's husband had a friend who was a realtor, and they're moving up in their price point. And they called me the other day finally, and they were like, we need a referral from you because we know that Sotheby's is going to have the most like market knowledge and hip pockets in the areas that we're looking now. So you're kind of doing the right thing, already being in the right place, but you just have to convince them, right? Does that make sense? Tiffany, I don't know if that helps a little bit. There's not really a good answer for that question, unfortunately. So then in a contract, both parties usually make representations, and we're in section 7, we're agreeing that everyone has the legal capacity to sue it, to sign, that the client isn't party to another agreement. So they're letting us know, like, I am available basically for you to work with exclusively. Obviously these are our forms, so they're very friendly to us, right? We wrote that, realtors wrote them for realtors. So it's very realtor friendly, but the client's representing that all information relating to their ability to acquire property is true and correct. And then we're asking them to disclose if they're connected to a relocation company. So that's helpful too, that if you get a buyer's rep signed with them and they don't put anything in there, if they surprise you later, this is just a little bit of leverage for us in our conversation with them, right? So any questions so far? No? Okay. So then section 8, this one's really, really important. We're going to just talk about intermediary in general for a second. So when you do intermediary, which I've already given you my little soapbox about how it's not my recommended way of doing business, but I understand it happens all the time, and it's okay to do it if you do it the right way and you know what that is. And if you're not in a situation where multiple offers are happening, I just really discourage you from doing it that way. But you basically have to have a signed representation agreement with the client that says that they consent to intermediary. And then when you actually are doing an offer and a contract for them, there's another intermediary notice that needs to become part of that contract, where both parties, both the seller and the buyer, are reiterating again in writing that they're consenting to this. So you need kind of 2 acknowledgments on the part of the client that they're on board with intermediary. You need it here in this representation agreement, and it's part of this buyer's rep agreement, and it's part of the listing agreement, where you're going to check this box 8A. Yes, we do want to see brokers listing. So you need this box checked here to cover yourself if you're going to do intermediary. So make sure you check that box. The other option would be if they don't ever want to be in a situation where it might be intermediary and the broker's representing both sides, you would check this B box. But that, I have never one time in my 16 years in real estate seen that one checked. So that would be very unusual, but you do need to make sure that this box is affirmatively checked when you're filling out the form, because it's the buyer's consent that they are open-minded to intermediary, right? And so this is kind of explaining with appointment versus without appointment, these next two paragraphs. And then it's all about how we're going to do this. And this 1, 2, and 3 is addressing the intermediary notice form that we're going to follow up with in the contract and how we're going to do it. And in that form, and we can look at that form too, it says broker will appoint or broker will not appoint. So we'll walk through that. So any questions about that? This reiterates then where it's bold here. When something's bold in a contract, it means it's like they really, really want to put the receiving party on notice. So this is a notice here that it says, if we are acting an intermediary, these are the things that we can and cannot do. And we'll just go through them. We cannot disclose to the client that the seller or landlord will accept a price less than the asking price unless otherwise agreed in a separate writing by the seller or landlord. We cannot disclose to the seller or landlord that the client will pay a greater price than submitted unless otherwise. It's just trying to make it really fair, right? We can't give information that we're not allowed to give, since we're kind of on the same side if we're intermediary, even if it's two different agents. So we cannot disclose any confidential information that seller or landlord or the buyer specifically instructs broker in writing not to disclose unless otherwise instructed in a separate writing. So basically what this is saying is that, and we're going to get down to this a little bit later in the document, but there's a lot of things that we can share and people always say, oh, you can't do that. And it's like, well, you can do what your client wants you to do. So if your client authorizes you to share this information, you can share it. And we're going to get there in a second, but that's just an interesting point to kind of note, is that whatever we have to do what our clients want. And if it's something that seems out of the ordinary, we should get it in writing that they wanted us to do that. But, and then the other two things are that they need to treat all parties to the transaction honestly and comply with the Real Estate License Act. So that's just kind of explaining how to act.
I have a question.
Yeah.
On this, because I want to make sure maybe we can discuss this offline. When you have the client sitting there, and I fully understand, like when you're in contract law and everything, how much can we go back and explain that to them? Because you're in a very close area to where if you explain too much about this contract, you then start treading over into legal opinion. But, if they're saying, okay, on the intermediary, when you're explaining to them saying, look, if you sign this, you're acknowledging that we will be doing this in-house. I guess in the classes that I took, they never said how much you can explain this contract or any of the contracts. And then where is that line where you then transition over into being an attorney? Because it is a very gray area, because you cannot give them any information that would infer legal counsel. So,
right. So,
when you're explaining this, and I guess what I'm saying is you pretty much just saying, here's the contract. I can answer questions that is related to how I'm doing the business, but I cannot give you legal counsel.
Yeah. So, and you can, well, and I think you said it right. And it sounds like you have the right idea. That, we're authorized to explain the terms on our promulgated form. If it seems like you're dealing with a client who's stuck on a particular issue or isn't understanding what you're trying to explain to them, that in the promulgated form, it's always a good idea to say, you know what, I would love for you to talk through this with the attorney at our firm. And then you connect them to me or Angela, or the title company attorney is always a good person to turn to explain if there's a term in the contract that seems confusing. But legally,
oh, that's good to know that we can refer to Angela or someone. I wasn't sure, being new. I'm like a weak newbie here. I wasn't sure how much we would refer in-house, saying, if you'd like to ask an attorney specific questions, I can either refer you to in-house counsel, or, there's attorneys at title companies, or you can reach out to a real estate attorney.
Yeah. And that's exactly right. And I think it's fair for you to have confidence in your knowledge of the forms once you have the knowledge of the forms, and to explain how the forms work. You're allowed to do that. I don't think you need to feel like you're practicing law. If you get to an area where you feel like you can't explain it, or that the client is stuck, it's always a good idea just to say, you know what, I'm not an attorney, and it sounds like you want a really detailed explanation of this. So I'm going to connect you to our attorney at the company.
Perfect. Because these are all these questions I had in class. It's like, because, I've had law classes, and you have to be careful because people can infer so much.
Yes, that is true. That is true. That's a good question though. But yeah, if you ever feel uncomfortable, or if you ever just feel like a client is picking at you and like pushing, feel free to let them know that like we have attorneys here at
Perfect.
our company that you can
Yep, that's
talk
what we're
to.
here for.
Okay. Sounds
right.
perfect.
That's
Thank
right.
you.
Okay, so then we are just disclosing here in section 9 that we have other buyers that might be in the same buyer pool as them. And then, section 10 just covers confidential information that we're not going to share. Now, this is the really important one that I wanted to point out was 10B. And your buyers need to be aware of this, and you as agents need to be aware of this. And I don't think that most agents are. So you guys are ahead of the game for even being here. Unless otherwise agreed or required by law, a seller or the seller's agent is not obliged to keep the existence of an offer or its terms confidential. If a listing agent receives multiple offers, the listing agent is obliged to treat the competing buyers fairly. I mean, what that means is that if I'm the listing agent and I get an offer from Melissa's client and an offer from Sarah's client, it's Sarah, right?
Yeah.
Okay. And Sarah's client, I could forward both of those to each other and say, Melissa, you can see what Sarah's client offered, and that your buyer's offer is not confidential. So just be aware of that, right? I could only do that with my seller's permission, of course. But if my seller said, yeah, give everyone all the information, that would be fair, right? For Melissa to see what Sarah's buyer is offering and Sarah's buyer to see what Melissa's buyer is offering. Yeah. So it's
a big deal.
it's
big.
yeah. And I mean, does that ever happen? Not really. And you have to be conscious, and it's happening a lot in multiple offers right now. But if you get 3 offers and 2 of them are financing and 1 of them is cash, it's fair to say to all 3 buyers agents, just so you know, we have 3 offers, 1 of them is cash, and then that way everyone has the same information. Of course, the cash buyer knows that they're the only cash buyer, but you just have to be giving everyone the same information. So Angela, do you have anything to add here?
No, I think that's a really good way to succinctly describe it. So yeah.
Your buyers just need to understand. And to this point, if you have a buyer that's super sensitive or someone that's high profile, you need to make sure you have some type, and they don't want the terms of their offer to be disclosed. And this of course happens only when we get into really crazy high price points. We can have some type of NDA or something drafted between the seller and the buyer that they're agreeing that the terms are confidential, right? So if you want to keep it hush hush, we have to agree separately in writing, because without that, both the listing agreement and the buyer's rep agreement provide that we can share that information. Of course, with the permission, the seller has the right to decide what the listing agent can and cannot share. So does that make sense? That's an important little nuance you guys just need to know about. Okay. So here we're going to talk about our fees. This is another provision that gets discussed a lot. So usually, we ask for 3% here. The parties agree that the broker will receive a commission calculated as 3% of the gross sales price. Or if you're doing a lease, generally speaking, for a residential lease, it depends what market you're in, but it's anywhere from 25 to 50% of 1 month's rent. So you just kind of need to know your market. And one way to do that is get into MLS and look and see what's kind of being offered. I would say in Fort Worth, it's usually 25, and in Dallas, it seems like 50, but that's my personal experience.
And it's not even the whole market. You could be looking at places within a 2-mile radius, and it'll vary from 25 to 50 and have 40 in there. So yeah.
Yes. So then this is explained. This is the part that we get questions about all the time from the handful of buyers that actually read this document when we send it to them. This is what they ask about. So, broker will seek to obtain payment of the commission from the seller, landlords, or their agents. And then this is underlined and bolded so that it's super conspicuous and the buyer pays attention to it. If such persons refuse or fail to pay the broker the amount specified, client will pay the broker the amount specified. And a lot of times buyers are like, I don't want to do that, and they cross it out. I mean, I'm usually fine with that because I feel like it would be very rare for you to be working with a buyer in good faith, find them a house, and then either the broker or the landlord wouldn't pay and the buyer would be like, well, sorry, I found a house, see ya. But I mean, that might happen, especially if you're finding for sale by owners. But if you're finding for sale by owners, we have separate forms that can kind of acknowledge who's going to pay what, how much. Does that make sense? You just have to be proactive about it. But It's 9:26. So those of you guys that want to go join the new agent, Jessica's meeting here, I'm gonna let you guys go and we'll just record the end of this so you can catch up. Yeah. So then, earned it. So does anyone have questions about that? My point was, a lot of times buyers will want to cross this out.
Mhm.
And I always say, like, that's fine. You don't want to get started off on the wrong
Yeah.
foot or like really, really push.
Okay.
So as a general rule of thumb, we're not going to sue our clients for commissions anyway. So we want to have like clients that want us to get paid because we did a really good job for them. So this is earned and payable, and you'll find the same thing in the listing agreement. It just defines when we've actually earned the commission, and it's earned when we've entered into the contract or when the client reaches the agreement. So that's when it's earned, and then it's payable at the earlier of the closing, the client's breach of the contract, or the client's breach of this agreement. So this actually has some pretty big teeth, and it would afford us the opportunity to go after our clients if they act in bad faith. Do we do that? Not very often, but just so that you guys kind of know what's in here. So does that make sense? Questions there? Just to kind of be aware of what our rights are. Additional compensation. If a seller offers compensation in excess of the amount stated, then broker can retain that in addition to the specified commission if there's like a buyer's bonus, buyer's agent bonus or anything like that. And then notwithstanding any provision to the contrary, and that's general legal that says, ignore everything else that this contract says and this trumps. That's like a term of art. Notwithstanding anything to the contrary contained herein is always like, forget whatever else the contract says, but this is the key. Yeah. If a client acquires a property listed by broker will be paid in accordance with the terms of broker's listing agreement with the owner, and client will have no obligation to pay the broker. So does that make sense? It's just saying the listing agreement trumps in terms of how we get paid if we do intermediary. So, and then this says if we are collecting any other fees. So if client uses broker services to procure the negotiation of improvements to the property, broker will receive fee. I don't usually put anything in this blank. Angela, I don't know if you do.
I don't, but I know some people who do stuff with new construction, sometimes they will do it. They'll get a piece of the lot that you're selling initially and maybe the land, but I've never personally done it. And I don't see it much, but I do know it happens.
Okay, awesome. And then if broker refers clients to any party to a transaction, broker may receive a fee. That's just kind of a disclosure. And if that happened, we would have an affiliated business disclosure that they would fill out separately. And then this would be if you guys had some weird provision that you were going to include in there. Okay, so then this is another important part, and this is it's almost 9:30, so I don't want to keep you guys. The protection period, this basically says that from the day the agreement ends and continuing for X amount of days, if you send them a list of all the properties you introduced them to, you are protected. So if a client or a relative of a client agrees to acquire that property that you wrote in the notice, then the client will pay you on the closing as if the agreement were still in effect. And this provision survives termination. So basically this is protecting you. If you showed them 100 houses and you send them the list within 10 days, and then 2 weeks later, they buy one of those houses, you are entitled to your commission and you can kind of go after it. And this happens sometimes where the agent finds out after the fact, like, oh my gosh, they bought that house or their brother bought that house and they tried to cut me out or whatever. So this is how you protect yourself.
And Zareen, this works also if they have, if they've hired a second buyer's agent, right? So as opposed to buying it on their own independently, right? Because I know on the
No.
seller side, no? Okay.
So this paragraph right here, I think this paragraph will not apply if
Oh, there we
client
go.
during the protection period is bound under a representation agreement with another broker. So unfortunately, the listing agreement is the same way, and it stinks so much where if you do all this work and you find it and your agreement ends for whatever reason and you deliver the notice and they buy it within your protection period, if all of those things happen, but they end up choosing another agent to actually represent them, like, unfortunately, you're out of luck. And it's the same thing with the listing agreement. If you have a listing agreement and it ends, even if you give them the list of the buyers that might buy and one of them ends up buying, if they use another agent to represent them, then we're out of luck. And that's just to prevent like arguments between realtors. But this is worthwhile to know. And I would put like 90 days in here, or at least 45 days. Angela, I don't know what you put.
I've never done that long, but I like the idea.
I
We're
can't- I
more like
can't hear.
21 or
Right.
something. Okay.
But the key is that you deliver the list of the properties,
Yeah.
right? And you can go back through your showing time log or something like that and deliver it. So that's an important provision just to remember. And then, client authorizes and broker may instruct an escrow agent to close and pay the broker. And then it says where we're going to get paid. I usually put Dallas County, whatever county my office is in. And then the rest of this is, boilerplate language where there's a mediation provision. And then there's a default provision. If either party fails to comply, the non-complying party is in default. If client's in default, they're liable for the compensation you would have received if they didn't default. And then if broker is in default, it says client may exercise any remedy at law. That's very generic. It basically means they have to sue us, right? Or go to mediation. And then a provision regarding attorney's fees, a limitation of liability provision, and then any addendum that you're going to deliver. So information about brokerage services always checked, but protect your family from lead in your home. If you're looking at old homes, you may just want to check this box and deliver that pamphlet to them at the beginning. I call it the don't eat the paint chips pamphlet because that's basically what it says, but it's just a good protection. TAR has some really great forms. If you have a buyer that's like super information hungry, TAR has a bunch of good promulgated stuff. You can deliver them and you can kind of include them as part of this agreement. It's just more kind of CYA stuff. So, and then additional notices, the fees are not controlled. We're just saying that we don't kind of price fix, that we comply with fair housing. We're disclosing that we're not an inspector, a surveyor, an engineer, any of those things. They need to seek experts, that they should get title work, that they can get a home warranty, that they may be being recorded when they're in properties. This is a good one. And advice, this is a good form that really, really protects us, which is why I encourage you guys. A lot of agents just get this signed like when they're writing their first offer because they're already getting a bunch of paperwork signed. I encourage you to try to figure out a way to get this signed like when you truly start working with someone. I know Carol Van Hook, she's awesome. She's an agent in our Fort Worth office and she's been a broker forever. She owned Mira Vista Realtors before we all joined Briggs Freeman, but she always says that she'll take a buyer out looking one time. She says she's telling them it's a first date. And when they're asking her questions, she's hilarious. I cannot deliver it like her. I need to maybe I can get her to come and tell at our next, because she's awesome. But she says, and when she's driving them around and they're asking her questions and her advice, she's like, well, once you're engaged with me, I can share a little bit more with you about this. So that's how she has always done it. She's like, this is a first date. And in the ninja way is to say what may, in a listing presentation, they say, what may happen at the end is that like, you may not want to retain me. We may not decide it's the right fit. You kind of make it mutual.
Right.
But it's a really good way to do that. And then you can kind of get this sign and say, okay, now I officially represent you. I'm going to give you all kind of all the goods. Yeah. And so, and then there's a wire fraud warning. And then of course, again, a reiteration that we're not lawyers and we can't give legal advice. And then you put the broker's name here, and then you're checking the box, you're signing on as an authorized agent on behalf of the broker, and then your name there. So that's the quick and dirty of this form. Did I miss anything, Angela?
I don't think so. Good.
No?
Good
Does
stuff.
anyone have questions? I want to make sure that you guys get into that meeting because I don't want to keep you. Okay, yeah, go for that. We're covered here. I'll see if I can get Carol to come and just explain because she's a hoot and she's really good at it and been doing it forever. And the rest of us can stay on if you want. I don't know who else we got. No, go to that meeting. So what's happening right now is there's a in-office huddle for the Turtle Creek agents, and you should go and like meet the other agents. As a newer agent, it's really, really important for you guys to be, showing up at meetings, getting to know people. I'm sorry, usually we don't double book these on the same week, but because last week was no, this is good. No, thank you guys for coming. And the rest of you guys, if you're in this Turtle Creek office, I would encourage you to try to come to these huddles because you'll meet experienced agents. You'll hear what's going on. It's good to be up at the office. That's how you're going to learn the business, learn the people. Catherine's nodding her head. She just signed out, but oh no, you're there. You moved. So thanks for coming, guys.
Okay.
Anyone have any questions? Is this helpful? Is there
I have a
another form that
question.
you guys want to talk about specifically next time?
I have a question about special provisions.
Uh-huh.
What are some types of you would ever see in?
I missed that. Say that again.
They're doing construction next door.
Yes, they are.
What types of things would you see 17 under special provisions?
In the buyer's rep
I know we
agreement,
typically try to stay away.
you know, I
Yes.
can't say that I've ever seen anything written in there really. Angela, have you seen anything?
No, I don't. Maybe they might have excluded something, maybe that someone else had shown them or something, maybe like that. Or, you know, a friend who they've talked to about selling without an agent, something like that, maybe.
Yeah, that's probably exactly what goes in there, is that they're like, well, my neighbor, I might buy this house from my neighbor, and if I do, we're going to do it without agents. That's probably exactly what goes in there. And then you would just, we could write a sentence that kind of explains that this doesn't specifically cover
That certain property.
that property. That's exactly right. That's a good point. Good call. Anyone else? I'm going to show you guys the intermediary form if you have time and are interested, only because this is like an FAQ. Angela, you probably get this a lot, or I see people doing it the wrong way, which like stresses me out. So can you guys see the intermediary relationship form now? So this is the form. So if you filled out your buyer's rep agreement and you checked intermediary box, or you filled out your listing agreement and you checked the intermediary box, when you're actually writing an offer for that party, or a contract, if you're the listing agent and you get an offer from someone else at Briggs Freeman and it doesn't have this form, you obviously need to add it. As the buyer's agent, if you're writing an offer for someone at Briggs Freeman, you need to include this with your offer, make it a really good, clean offer. This should be included. So you're going to put the seller's name and the buyer's name here in the prospect, and then you're going to put Briggs Freeman here. Then you're going to put the name of the property. Sorry, I just went into my zip forms. And what today's date is. And basically this document says, you know, under this notice, owner means the seller and prospect means the buyer. Broker's firm represents the owner under a listing agreement and a prospect under a buyer tenant rep agreement. In the written listing agreement and the buyer tenant rep agreement, both the owner and the buyer authorize the broker to act as intermediary. And so, and when we make an offer to lease or to purchase the property that is, you know, in an intermediary situation, broker will act in accordance with these authorizations in both of those documents, right? That black bolded language that we went over. And then this is the part that agents always get confused on. And I don't think it's that confusing. So let's just go over it. So if you have a listing and your neighbor decides they want to buy that and they didn't need, there's not going to be multiple offers and you're very confident in kind of repping both sides, you're going to point this in this. If you're going to do it where there's no other agents involved, it just says broker will not appoint licensed associates to communicate with, carry out instructions of, and provide opinions and advice. So you're just saying we're not making any other appointments. It's just me. And both parties are acknowledging that when they sign here. Okay. If, you know, I'm writing an offer on Melissa's listing, that I'm going to say broker will appoint licensed associates. And I think that's confusing because this will and will not could be a little bit more separated, because they either will or they will not appoint licensed associates. So if I'm writing an offer on Melissa's listing, we're going to say Melissa France is assigned to represent the listing, and Zareen Brendel is assigned to represent the buyer. So then we're making clear, like Briggs Freeman is the broker, but she represents the seller and I represent the buyer. And because we have appointed. Does that make sense? Pretty straightforward, but this one's always confusing to people. Any questions? I can't see the chat. So if you have a question, speak up. And then, you know, by acknowledging receipt of this notice, they reaffirm their consent. So we're saying again, you understand what's happening here. And then, you know, if there's anything, this is giving you another opportunity to see why, if there's anything else you want to disclose, or if it was the situation where I was talking about, where it's like, you know, my neighbor on my left wants to sell to my neighbor on my right, you could disclose there, you know, like we're neighbors, or if I wanted to say, if I had a listing and they didn't know it was my neighbor, I might just want, it's always better to just give the information up front, because then you don't look like you're hiding anything. Because inevitably people find things out and then they feel like you hid something. So it's better just to be upfront about it and be like, this is my neighbor. I sometimes tell her about listings that I have and she's interested in yours. And then it's not a surprise.
I
They
have a
don't feel like they
question.
got tricked.
I have a question going back on the broker.
Sure.
When you're doing that intermediary, from my understanding from the classes, the broker would be in the capacity, it would almost be like like Robbie would appoint two people, the way they explained it. So that in an intermediary, Robbie would appoint Melissa and you to be the two assigned agents to execute the intermediary.
Yes.
Okay. So then that is going to hold the broker capacity. So then if you're on the other side, the will not, so that would you as the agent just be that go-between, almost executing the transaction, just more or less processing the paperwork?
Yeah. So, I mean, to be clear, like our broker is the Briggs Freeman corporate broker. So Robbie is the sponsor for that broker, but really the broker is Briggs Freeman, right? And, but yes, Briggs Freeman is appointing Melissa as the sellers and me as the buyer. And we have underlying representation paperwork that already supports that, right? Because Melissa has a listing agreement and I have a buyer's rep agreement.
Okay.
And if you check this box here and you have will not, basically what we're saying is, if I have, like I said, if I had my, a listing in Preston Hollow, but I live in Fort Worth, but my neighbor's been looking in Preston Hollow, I would say I'm going to do both sides, and Briggs Freeman, the broker, is not appointing licensed appointees to communicate with. It's
Correct.
just me.
So then really and truly the buyer and seller become customers.
Yes. And I'm glad that you said that, because, this is the IABS piece, but I had a piece about, I'll send it to you. I'll send it to you. It basically explains when you do intermediary without appointment, which is the situation where one person is representing both sides. It clarifies like the things you can do, and it answers the questions of like, what are the things I'm allowed to share?
Right. I mean, how much, I mean, you're saying you got to be honest and fair.
Yeah.
And you've got to stay right there, because you're not holding any fiduciary duties at the point. You're just strictly that conduit between the transaction.
Well, I think I don't know. I wouldn't know if I would say that you would hold any fiduciary duties. I think you probably have a fiduciary duty to both, but your capacity is limited, and everyone's agreed that they're okay with that.
Okay. I guess
I'll send it to
send the
you.
information. Yeah.
to be
Because I want to
clear.
know how much you're going to run in that fiduciary duty.
Yeah. Well, again, Angela, and you may want to clarify there. I don't want to say that you don't have a fiduciary duty
Yeah.
to your clients, because I think you always have a
You do
fiduciary
have,
duty.
yes,
You
right.
do, but
Kind of
it's
in
like,
a communication standpoint is what you're really limited on. So yeah,
Yes.
you've got the same standards of care that.
right. I guess that's what I'm saying. You have the care. I guess
Yeah.
when I'm thinking fiduciary duty, I'm thinking more in that extreme side to where you are truly, I guess I'm thinking that when you're holding everything that we've learned also from the past, some of my experience working on Wall Street, when you're holding that fiduciary duty, you are truly taking care of ultimately that client. But here, you're still going to be honest, you're still going to do due diligence and care, you're not going to misrepresent, but you cannot share confidential information to the buyer and seller that would alter or give advantage one over the other.
Correct.
Yeah, and I can't find it right now. I was looking real quick. I'll send all of the new agents that FAQ about intermediary situations and what you can and can't do, because I sent it to that new agent the other day when he was like, well, I consider myself still representing the sellers. I was like, no, bad. I sent him this because I wanted him to really read when he's in that position where he said, I represent the buyer and the seller, and this is intermediary without appointment. You can't think like I really represent the seller, like no way. So I'm going to send you guys that TAR FAQ to read through that really clarifies what you can and can't do. And it's basically says, and they go into greater detail, but you can still give them information. It's not like you're like, oh, can't help you with comps, but you can't say, well, based on the comps, like you should offer this much. You can say like, here are the comps. the industry standard is that you might do this. You can tell them what's common in the industry. You can share facts, but you can't just share your personal advice. So the FAQ will be more clear, and it's official coming from Tara rather than me. So I'll send that to you guys.
Okay,
But it's really
perfect.
helpful for everyone to read it, for sure. It's not a long read.
Anything you have. I mean, this is great. I mean, this is exactly what I was seeking, because these are all these questions you have. I mean, you understand the core tenets of all this, but it's the nuances
Yes.
that do not get discussed in class.
That
What
is
really happens?
That's exactly why we do all this new agent training, because they teach you like what the rules are and what you need to do not to get sued, but they don't teach you how to actually take care of people.
Correct.
And what best practices are and how to have these conversations. So that's why we do all of this follow-up stuff. That's exactly right. Good deal. Well, does anyone have any other questions? Thank you for coming. Just so you know, like we keep track of kind of who's coming, and we'll check in with you guys on a regular basis as new agents. We kind of expect for those of you that are new to show up to all of this new agent training that we're offering, because it's the only way you're going to learn, not on a client's back, right? Is for us to kind of proactively talk about it up front. We'd rather you have this conversation now versus learn it the hard way at the expense of a client or at your own expense. So good deal. Thank you for coming. Angela and Jesse, I hope to meet you guys in person one of these days. I'm up in the Turtle Creek office sometimes. Sometimes I pop into Fort Worth. So hopefully hope to meet you guys soon.
Definitely. Come, I probably will come for is it office hours?
Phone duty?
Yes, phone duty.
Okay. Yeah.
So definitely try to meet up.
All right, cool. Well, I'm around, so hopefully I'll see you guys. But it's good to see
Okay.
everyone. Thanks for coming.
Bye.
Bye.
Thank you.
Bye. Thanks for.